We will call the meeting to order for the Wednesday, September 23rd BZA meeting. If you would please all rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Tonight's case should be fairly straightforward. We shouldn't have to address some of the things that we have in our normal notes, but I will give a brief explanation of what's going to happen tonight. So the staff is going to give a brief presentation of the appeal, and then you'll be given the opportunity to speak for or against the appeal. And then we'll close the public portion. Then we'll request potentially anybody that has spoken, ask some questions, ask them to come back to the podium. And then at the end, we'll vote on the decision, and it'll be a straw vote. It'll carry forth, and you either get denied or approved. And if you get approved, you just come to get the certificate from the staff. Let's see. Do we need to do a roll call vote?
Mr. Bartelt? Here. Mr. Hill?
Present.
Mr. Reiner?
Here.
Mr. Schupp? Here. Mr. Roberta?
Here. Okay. So the first case of this evening, and the only case for this evening, would be for BZA 2020-06. This is a request for a variance for a front yard privacy fence. Location is 7875 Vegas Drive, and the applicant owner is Jeff Reuter. Does the staff have a presentation?
We do, and we're going old school printing out.
Were you doing swearing in, or is that later?
We'll swear in once. We'll swear them in now. So anybody that's going to speak, anyone's going to speak, please raise your right hand. You swear or affirm you will tell the whole truth, nothing but the truth before the Board of Zoning Appeals? Say I do. Thank you. You may be seated. Now we'll continue on. Thank you, Bob, for the reminder.
All right.
So if you give a presentation, we're going to do it old school on paper.
Yes, sir. Okay. Thank you. Thank you for your patience, gentlemen. And if I go too fast, just let me know. The applicant tonight is requesting one variance from section 12.8.1 for a front yard 6-foot privacy fence. The property is located at 7875 Vegas Drive. It is located in the White Oak character area of Colerain Township, which is located south of Galbraith Road and east of Cheviot Road. I made pretty aerial so that you can see right there. The property is a corner lot located off Vegas Drive and Rocker Drive. Normally I would zoom in and show you closer aerials, but I can't do that right now, so it'll throw it off.
You did in the PowerPoint though, so we can reference that.
Great. So single family house is approximately 1,600 square foot, built in 1963. The property itself is zoned R6 for urban residential, as well as all the other adjacent property owners are zoned R6 as well. The applicant received a notice of violation on July 22nd, 2020 through our planning and zoning code enforcement team for installing fence posts that were 6 or 8 feet high. The applicant then applied for a zoning permit a few weeks later, resulting in having to go to the Board of Zoning Appeals because the applicant wanted to put this fence in the front yard since technically it's a corner lot. And if you slowly go through all the images through the PowerPoint, you notice the posts are up. It's important to note that the property adjacent to the north on Rocker Drive, it's 3490 Rocker Drive, went in front of the Board of Zoning Appeals in 2003 for variance to add an addition for a garage. And this encroached on the side, the front and rear setbacks closer to the subject property. The applicant states one of the needs for the privacy fence is to help promote privacy due to the hardship of the variance back in 2003. And then, so the variance request tonight is from section 2.8.1 of the zoning resolution. It states that fences in all residential and business districts may be erected as a privacy fence to a maximum height of 6 feet in a rear yard only. Such fence may encroach into a side yard up to a maximum distance equal to 25% of the sidewall length. As you note in the, if you go to the next slide, then you can see that I have highlighted the approximate fence location in a darker red. And then you can see in a lighter red dashed lines where a 6-foot privacy fence would meet in compliance. So the applicant tonight is seeking a variance to allow for the construction of the 6-foot tall privacy fence that would be located in the front and side yard of the property. So the fence is extending out more towards, Rocker Drive, approximately 31 feet more than it is allowed. Or, yeah. And the applicant is here and he can help clarify my presentation. The design of the fence is wooden privacy. It's aesthetically pleasing, but just unfortunately, it's located in the front yard. So with this, staff finds that the proposed variance is not the result of a hardship on the property owner. As such, the granting the variance would grant a consideration that is not available to other property owners within the neighborhood. 2, staff recommendations have been consistent with recommending denial on similar variance requests. So if you go to 2 in staff findings, I put a brief history of similar variance requests dating the past 5 years, just to show that staff is consistent with recommending denial for similar requests. And you guys have voted differently on certain instances. And we had 2 in 2018 alone. So we haven't had a front yard variance in about 2.5 years. 3, the property in question would likely yield a reasonable return without a variance. 4, there are no unusual topographic or site configuration issues related to this property, which would prevent the reasonable application of the front yard regulations. And then lastly, by taking into consideration the benefit to the applicant, if the variance is granted as weighed against a potential detriment to the health, safety, and welfare of the neighborhood and broader community, staff finds that substantial justice would not be done by granting the variance for the front yard fence. And then staff recommendation is denial of the variance. And I would be happy to answer any questions that you gentlemen might have.
Any questions for staff?
I have a question. How was this brought to the township's attention?
It was reported as a violation from an anonymous source, and our code enforcement team wrote them a violation. And they were notified that they cannot install a fence in that location. And they applied for a permit, and we had to deny them.
Thank you.
Any other questions?
Yeah, I have a question, Jesse, on the drawing that you have with the solid red line, which is where the request is for, and then you have the dotted lines. I'm presuming that's what's permissible?
Yes, sir.
Would the rear line be permissible as well, the solid red line in the back?
Up to the point of the
dotted
red
line.
dash, correct.
Okay.
Mhm.
Any other questions? I see none. Does the applicant have a presentation? Please approach the podium, give us your name and address, please. And if you feel comfortable, you can remove your mask as well.
I'm afraid I'm going to have to because my glasses steam up and
That's
then
perfectly fine.
things get worse. Chairman Roberta, members of the board, my name is Jim Reuter. I'm an attorney, and in this application I represent my son, Jeff Reuter, who is here with me this evening. I want to thank Mr. Urbancic for his helpfulness and professional courtesy in accepting the photos that I presented and printing them out for you all. We expected they'd be on the screen, but we're all looking at the same thing, so that'll be fine. This is a fence variance. The zoning resolution provides that a privacy fence can be installed only in the rear yard. Some dates are probably helpful. The house was built in 1963 with a patio. The patio has always been on the west side of the house. The patio was improved substantially in the early 1990s. Colerain adopted its zoning resolution in 1994. 2003, this board, not these commissioners, but this board approved a variance for the house immediately to the west at 3490 Rocker, which basically allowed that owner to build his addition at its closest point is 17 feet from the property line. So that basically eroded half of the required backyard setback for this district. The applicant, my son, bought the house in July 2018, and his goal, simply stated here, is to be able to enjoy his backyard with some modicum of privacy. As you could probably tell, I hope, from the photos, that the building at 3490 Rocker, which is a 1.5-story building, essentially looms over his patio, and it's essentially the biggest feature in the backyard. In addition, there is not insubstantial pedestrian and vehicular traffic on the Rocker side, which is open to view for quite an angle, and it's this that compromises his privacy in the yard. The proposal is to build a 6-foot privacy fence along the west line of the property, and then at the southwest corner of the property, make a 90-degree turn and come back about 30 feet on Rocker. There are several photos that describe where this would be. If you look at my application, the justification statement, I did attach a photo of a split rail fence which was taken down, which is in the location of the proposed fence here. It would go slightly further to the walk from the public sidewalk on Rocker to the back door. That's the location on the ground of where this proposed fence would be. In my packet, in my appeal packet, that was exhibit number 6. The 30 feet on Rocker leaves about 75 feet of completely unobstructed view on the Rocker side. This is not a case where the fence goes into what is normally considered to be the front yard, blocks anybody's view. In fact, the code itself sets out a vision clearance triangle in section 12.4, and with that 75 feet left wide open on the Rocker side, there is no safety issue. In fact, the vision clearance triangle is roughly doubled. This is an attractive fence. It's in a reasonable location, and all the neighbors have consented. I have those consents, and with your permission, I'll approach and hand those out to you. Is that right?
Thank you. Make a note for the record that we've received some documentation from Mr. Reuter showing that we've got signatures showing that they have no issue with the appeal. And there appears to be 1, 2, 3, 4 people that are in this particular packet.
These are all of the owners who were the adjoining lot owners who were notified of the hearing.
Great, thank you.
I would like to turn to the staff findings and review those with the board and raise my concerns here. As to number 1, the staff finding is that the requested variance is not the result of a hardship on the property owner. Many of the properties located in the surrounding areas, including corner lots, do not have 6 feet tall privacy fences located in the front yard. As such, the granting of the variance would grant a consideration that is not available to other property owners in the area. I respectfully, I'd agree that there are other owners that don't have a fence, but as far as an advantage, certainly they could come to the board, just as we have done, file an appeal, and the board would hear that appeal and evaluate it on the facts presented in the law. So I really don't think that that is a valid reason to deny this particular variance. Number 2 is the staff has been consistent in its recommendations. I agree with that. In some of the cases, in all of the cases, the staff recommended denial, and in some of the cases, the board, after considering the facts in the law, found for the applicant, granted the variance, and that, I think, is appropriate in this case. The number 3 is a real concern. The property in question is likely to yield a reasonable return without the variance. Just to stop there. I think that most of us would agree that if a substantial portion of your property cannot be used in the same way your neighbors can, that eventually you can get a reasonable return, but it's probably not the same as if you had the same space, the same acreage available for all the activities that, say, a non-corner lot would have. There are many requirements that apply to a corner lot that don't apply to an in-lot. And I think the board, I would just like the board to keep that in mind. The harder issue is, the recommendation is the applicant can easily meet the rear and side yard requirements for a privacy fence located on this corner lot. And I'd ask you to turn to the PowerPoint. Which includes the dashed line where the staff's presentation was to the effect that the fence can be built where the dashed line is, and presumably along that portion of the west line north of the dashed line. I don't think that that's right. And if I can approach again, I've got a diagram that I put together this afternoon, which I hope explains it.
Yes, you may. You can approach. Let it be noted, we've received a document with a hand-drawn sketch and then a reference to our zoning laws.
The gist of the document is, the top of the document's to the north. The right is to the east, that's Vegas, the bottom is Rocker. The narrower part of the lot is the Rocker side. The longer part of the lot is the Vegas side. The rear yard is as I believe, as I've indicated on the diagram. And if you look, I attached a 12.1.5, and if you look at B and C, and then look at the graphic in the zoning resolution, which is there to explain B and C, the conclusion is that the rear yard is basically in the northwest corner of the subject property. And that's where this fence would be allowed under the resolution, only in the rear yard. That is nowhere near where the patio is. It's nowhere near the back door to the house. There'd be nothing there to, that's not where the privacy fence would be of any use at all to the applicant. Again, the point is, the patio, since 1963, has been on the west side of the house. The architectural rear of the house. 1995, if this provision was put into the zoning resolution that early, the patio ended up in the side yard. As to number 4, there are no unusual topographic or site configuration issues. This is, I think, a serious site configuration issue, which the applicant had no control over. The house was built this way, and to put the fence in the rear yard where it's permitted would be of absolutely no use. Number 4 also addresses the structure immediately to the west, which is 17 feet away from the property line and intrudes about halfway into the required rear yard there. I don't think that I think that that's a very important consideration for the board, and the outcome of that 2003 BZA variance could be mitigated by this board granting the variance as requested. I don't think that having the fence in this location could really amount to a detriment to the health, safety, and welfare of the neighbors in the broader community. All of the neighbors, anyway, who adjoin this property they don't only have no objection, they approve of the plan as presented. They had a copy of the site plan for the location of the fence, so there's no misunderstanding now about where the proposed fence would go, and all of them approved it. The other point I would make is that consider the west line of the subject property, which is the east line of the house at 3490 Rocker. That is the rear line of 3490 Rocker. 3490 Rocker is not a corner lot. So, if 3490 Rocker had filed an application to build a fence along that common property line at 6 feet high, I believe that the zoning resolution would have required that he be given a permit as of right. That's the rear line of his property, and his property is not a corner lot. So how could health, safety, and general welfare be offended if the board denies this application, and if the owner of 3490 Rocker came in and applied for the same thing, at least as to that line, that he would be given the application as of right? There's something wrong, and all I'm saying is that this is a case where you cannot conclude that somehow health, safety, general welfare is compromised by the proposal in this application. Lastly, I'd like the board to just step back and maybe take a broader view. You know, when the neighbors were first approached, when they received the notice from the notice of hearing, they were concerned because the zoning variance, as described, was for a privacy fence in the front yard. Once it was explained to them that it wasn't going to encircle the front yard as they understand the front yard, everybody was fine with it. I think that points to this. The definition of a front yard, and even look at this, a rear yard and a side yard, in the zoning resolution is entirely inconsistent with what most people understand a front yard and a side yard and a rear yard to be. If you stand at the southwest corner of this property, and if you go to the printout of the presentation, there are a couple of photos. Looking east on the Rocker side. So a person standing at that southwest corner would not consider himself or herself to be standing in the front yard by any commonsensical understanding of what that is. The fence in its present location is acceptable to the neighbors. There's a legitimate reason for it, and everybody has consented. I've said that too many times. You know, zoning is in derogation into the common law. The original idea was that a person's home is his castle, and you can do with it what you want as long as you don't offend anybody. We're at the point where this board, given your authority to grant relief from the strict application of the zoning code, should look at something like this, I think, and respectfully suggest, as just a step too far as restricting somebody's right to enjoy their property. The board has the authority, in a reasonable case, to grant the relief requested, which is essentially relief from the strict application of the zoning code. As I indicated in my state justification statement, I think that Mr. Urbancic and the staff have properly interpreted as to the, the fence couldn't go there, properly interpreted the code. I think that he did his job correctly, and I think respectfully it's this board's task in a proper case to grant relief, and I think this is that case. And I'd be happy to try to answer any questions. Otherwise, I'm at the end of my presentation.
Okay, we'll circle back with questions shortly.
Okay.
Thank you, sir. Anyone else giving a presentation or anyone else speaking on behalf of the appeal?
My son is certainly welcome to speak. Probably the way to do that would be if you have questions.
Well, do you have anything you want to say, sir, to this?
Adding to that, I don't know. I mean, I don't know if there's much more to say.
Well, if you're going to speak, please come to the podium so you, and then name and address for the record, please.
Jeff Reuter, 7875 Vegas Drive. Nothing more to add. The only reason this started was, wanting privacy in the back. A lot of cars drive by, a lot of foot traffic. Even in one of the pictures, I think that we caught someone walking their dog. It's just busy, so that was the whole reason for the fence in the first place.
Okay.
Appreciate your consideration.
Thank you. I see no one else in the audience, therefore there's no one to speak against this appeal. All right. So do we have a motion for the public portion to be closed?
So move.
Second.
We have a motion and a second. Anyone have discussion? I see none. Roll call vote, please.
Mr. Bartolt,
Yes.
Mr. Hill,
Yes.
Mr. Schupp,
Aye.
Mr. Reiniger,
Aye.
Mr. Roberto.
All right. So now we'll go to the question portion. And we'll start with Mr. Bartle.
Well, the first question is for staff. Can you one more time, looking at your solid red lines versus the dashed red lines, are you saying the solid red line that's going north-south, that's truly in the rear yard per what you think is zoning definition of rear yard is allowed?
So, good question. Based off 12.1.5 corner lots, there's a diagram, which I can't conveniently show to you.
It was presented in our packet, so we do have that. We can.
So this is what staff has been consistently recognizing, rear side and front yards on corner lots. So that's what staff based their assumption off of that, per the code.
So the
and
bulk
diagram.
of the north-south red line is allowed, is that correct?
Correct. Yeah,
Correct.
It
Yes.
should stop at the
Just-
dash line.
So past,
Yeah,
south of that dash red line is what isn't allowed.
correct.
Correct.
And if we take the applicant's definition of the rear yard, it would make the case worse for them.
Correct.
All right. Well, I had one question. In your kind of defense for why to do this, you did mention vehicular traffic and significant pedestrian traffic. I was like, you're near a cul-de-sac, so I was just curious other than people walking their dogs, what other traffic? You can come on up, but the point was made that you had significant pedestrian traffic. Is that truly a true statement?
Pedestrian for sure. I mean, a lot of people use the, walk around the cul-de-sac and head back, and, that's their walking path every day.
But normal suburban neighborhood traffic?
Sure. Yeah, I mean, I'd say that are you asking if it's
Well-
on par with?
I'm just saying, I read it says significant pedestrian traffic, so I'm just trying to, can you explain that?
Yeah. I mean, I don't think that there are more people walking in my neighborhood than, others. I think that it's probably more noticeable, being that it's, right open,
Right.
from the patio. But as far as, more than a normal neighborhood that has the, the same amount of homes in it, I'd say it's pretty on par.
Okay. The other point is, obviously, you bought the house knowing this neighbor's house was encroaching on the rear setback. So it's kind of hard to feel any sympathy in that regard. And then, so the garage addition that was granted the variance, I'm assuming is just a garage? Do we know that for a fact?
From my research, yes.
Okay.
And I actually have copies of the variance certificate from 2003, if you would like to see that.
Yeah, I mean, it's a garage versus a bedroom addition. And if that variance wasn't granted and that garage wasn't there, there'd be more grass in that person's backyard, which might lead to even more activity from kids playing, or people, playing cornhole or whatever. So technically, that addition might be helping your situation, instead of hurting it, but that's subjective. You could argue either way. But just different comments. But I know we're eventually going to discuss how we feel about this, but I would just say, I'll just say it now, that I would be okay with the entire north-south fence if we get it to that point and have to come up with some sort of motion. That's all.
Okay. Thank you. Mr. Hill?
Just a couple of observations. I do agree with Mr. Berto. Well, actually, I have a question for staff. With regards to the property on Rocker, is that considered a corner lot? Because when I look at this diagram, knowing zoning the way that I do, I would think that similarly to where you have your dashed line, that would be considered the rear yard where they could have a fence coming off their line. And there's a diagram in here, or a picture in here, where you could see where the building stops, essentially. So that they would be permitted to, per the code, to bring a 6-foot privacy fence off of that line, correct?
Off of,
Off Rocker. So this house here, if they brought theirs back like this,
correct, that would
that
be
would
permitted.
be permitted, correct?
And then, for the record, the setback requirements for that house has a front yard setback of 28 feet with addition, and then rear yard setback of 19 feet. When for an R6 zone, it's front yard setback of 30 feet and rear yard setback of 35 feet. So it encroached onto the rear yard property about 15 more feet than what is allowed.
I can definitely attest to the increase in the number of residents that are walking up and down the street with COVID, as well as you see more cars going up and down. I actually live on Vegas Drive, so I have seen definitely a lot more foot traffic, attesting to what he's talking about. The property is immaculate, and I understand the concern about having privacy with this house being so close. I do believe that corner lots, most people look at these and they go, oh man, this is a large property, and they don't realize that you cannot utilize a lot of it in terms of with the fencing and things like that. And I'm not sure, I don't think that the applicant purchased the property, knowing that that was going to hinder this particular application. And so I don't know if you can even talk about, did you purchase this property, or how did you acquire the property?
Purchased it, yeah.
Purchased, okay.
Yes, sir.
And when you purchased it, were you told by the realtor or anything about fencing regulations, or did you contact the staff or the township?
No, I didn't. It was a different scenario. I actually purchased it for my grandmother, and she went to assisted care, so retirement community, essentially. So.
Okay, thank you. Yeah, I mean, I think, for me, and I can't speak for the rest of the board members, I do believe that I think the township should look into maybe modifying some of those fence regulations, because corner lots, they do have a difficulty with some of the privacy concerns that a lot of folks have, and they don't realize that they can't put fences, privacy fences there. So that's my observation and my kind of comments and questions.
Mr. Shutt?
Yeah, I guess I have a question. I guess this would be for staff. I see an image, capture a Google image from August 2011, and it appears that there's a split rail fence. It looks very similar, although not as long on the east-west side, but is that something does that fall in line with what they're proposing? Not that that was put in properly either, but.
This
That was
is,
allowable because of what it is, but it will go a little further to the east towards the sidewalk, I believe.
Mr. Roberto's right.
Any other questions you might have?
No.
Thank you. Mr. Reiniger?
Some observations, and then just a clarifications. We're dealing with the privacy issue. I think you've got an attractive patio area that you want to screen. The house was purchased in 2018. The infringement of that other property on Rocker Drive occurred some 15 years prior, which was, so that existed when you was already there when you bought it. You're asking us to allow a change to what you walked into. And I also observed there are other 6-foot privacy fences apparently off Rocker in the backyard. My focus is going to be, and this will be discussion among other board members, if you want privacy, secure the patio area, but I certainly am not supportive of running that fence all the way out to Rocker Drive. I mean, the patio area is very nicely done. You want some privacy there, I can see that. I can't see running the fence all the way out to the sidewalk. That's my only comment. I don't really have a question.
Okay. Just point of clarification, the schematic that you presented to us was inaccurate because you're not taking consideration the front of the house. So the back of the house is actually the way the staff has drawn it is correct.
Can I address that?
Yes, you may.
I respectfully disagree with staff's conclusion.
I'm not saying anything about the conclusion other than the fact that the rear yard is where they said it was and not where you're referencing it. Your reference would be a side yard based upon the drawing within the page 112 of our zoning. Because if you look at the page 112 that you provided to us, the front of the house, if you'd have to rotate that picture and then it would match kind of what you have there.
No, respectfully, you have to flip it. You have to flip it like this.
Well, the front of the house is where you've got it drawn with the porch, correct? Front porch.
The front of the house, architecturally, is where
The
I
front
put the
porch.
little porch.
Right. And so then the rear of the house would be directly opposite to that.
No. If you, Mr. Roberto, the critical issue is which is the longer line. Look at B. The narrowest line opposite the public right-of-way shall be the rear lot line.
Which is still correct.
The
Public right-of-way would be Vegas, which is what the front porch is on.
No, the narrowest line is the north line and the south line. The north and south lines are approximately 106 feet. The east and west lines are about 135 feet.
Mr. Chairman, if I may, I agree with the applicant in this case because you can't look at where the house is actually facing. it is based on
Their
the
text.
narrow lot, yeah, so,
Okay, and I agree with
The
Mr.
applicant
Hill.
is
We need
correct.
to
Yeah.
review this because this has become a contention before.
Yeah.
And just common sense, the front of the house is the back is the opposite of the front of the house. And the way we have it worded here is not to that effect. So my apologies.
No problem. And if I can address Mr. Reininger's concern, I'd go back to the property owner to the west would get that fence along the common line as a right.
Well, that's semantics too, because we've got a differing opinion on that, but here's what I would like to continue on. So, because it's right now, I'm the one speaking. So first of all, caveat emptor, because you did buy it that way, but I can agree that there is a hardship because people can see in your back area, your back patio, your back where hopefully I'm assuming you have a back door there that has glass that people can see because every time they walk by, they're seeing in your home. So you are entitled to privacy. I mean, I completely agree with that. And I'm with Mr. Hill. I'm really not, I'm not going to get caught up in the fact that it's going out all the way to the street because it's not unappealing. This has been kind of my contention in the past as well, as far as what a side yard is, what a backyard is on a corner lot, where we are really making it, I believe we've made a hardship with the zoning. That's my personal opinion, and I would like for, our trustees and our zoning department to seriously look at this to make sure that this is not a hardship, because I believe you are reducing the size of these people's yards based upon, our language. And we've done this person a disservice by allowing the encroachment of the previous, neighbor to come up right on their back stoop. And so they're entitled to some sort of privacy because who knows what they're doing in that garage. I mean, it's whether it's a bedroom or not, somebody could go in there with spyglasses and just spy on them. They're not entitled to that privacy. So I'm okay with approving it really as the way it's been submitted. It's not, you're not going to box the whole thing in. You're just going down the one length, 30 feet to your sidewalk, I'm assuming, correct? So it's not over aggressive. It's not overreaching. It's not going beyond the house. It's just trying to capture that corner so that they have privacy when people are walking by. I get it. And that's my opinion on it. Anybody else have any discussion?
I would concur with that. I believe the ask in this case, particularly, the applicant is not going beyond or being substantial in terms of what they're requesting for this variance. They're just wanting some privacy, which, again, if they were boxing in the entire front yard, I'd say,
absolutely.
No, this is.
It makes sense what it is. To have the fence just stop at the corner, or even go on one panel length really doesn't make sense either. They're trying to go to a point, which is their sidewalk. It makes sense. Aesthetically, it still would be pleasing. Yeah, I'm for it. So, anybody else?
But they also could, in lieu of that 30-foot piece, put it where the dashed line is.
Certainly could, but then you're also reducing that space by whatever that distance is.
True. But it's feasible, I mean.
It certainly is.
So, anyway, yeah, I mean, what the garage and what's being done in the garage with binoculars or not, they're still allowed to have the privacy fence in the rear.
Sure.
So that's really not an issue. But there is a window on the second floor of that garage, so the fence isn't going to help anything anyway.
Sure.
So my only contention is that 30-foot piece
I
right
think
now.
the other thing that we probably should address too is technically, per code, it wouldn't even be allowed in what is defined as the side yard, only up to 20%, 25% of that west line. So, I mean, again, that wouldn't even allow it to come all the way over to that front plane of the home, based on the code definition.
Right.
So, again, I think that there's definitely a hardship
Yeah.
in terms of, they wouldn't even be able to, cover up their entire patio area, which defeats the purpose of the application at this point.
That's what I mean, if the applicant's diagram is correct.
Yeah.
the rear yard is to the north.
Right.
And that's the only place, well, technically they could put a privacy fence.
Yeah, and that doesn't make sense.
Right.
So,
And I see people walking around the corner, so now you're adding, that extra 30 is allowing them to get past the side of their house. So they do then truly have that privacy, all the way down till they're beyond the fence.
Right.
But to your point, they could move it in further in, but it's, if you go by this, it's really a moot point. I have nothing else. Does anybody want to make a motion?
I'll make a motion to approve the variance application as presented.
I'll second.
All right, we have a motion and a second. Discussion?
Mr. Sharp, you second.
Yes, he did. No discussion, nice note. Would you please do a roll call vote, please?
Mr. Bartolt,
Yes.
Mr. Hill,
Yes.
Mr. Shup,
Aye.
Mr. Reiniger,
No.
Mr. Roberto.
Yes. So your appeal has been granted. Congratulations. Just see the staff and they'll make the arrangements to make sure you get the proper permits. You're very welcome. I see on our next on our docket is number 4, unfinished business. I see none. Number 5 would be approval of our minutes from August 26th. Does anyone like to make a motion to approve those?
I will, but I was just curious. They seem kind of light, but I think legally you said it's okay that they're on the light side?
Since they're being recorded too, we don't have to
Put every,
go
given an
more in
overview.
depth. Correct. So if someone were to request the minutes, we would have them, the court reporter base it off the videos too.
right.
But if if you want me to start writing more in depth, I can do that.
Well, no, I think you should, it should be a 19-page paragraph because you got plenty of time.
I'll make a motion to approve the minutes.
I'll second.
All right, so a motion has been made. Second discussion? I see none. Roll call vote, please.
Mr. Bartolt?
Yes.
Mr. Hill?
Yes.
Mr. Shup?
Aye.
Mr. Reiniger?
Aye.
Mr. Roberto?
Aye. I see no administrative matters, so I can adjourn the meeting. Meeting adjourned.